The first form of grounds for dismissal and or discipline that I want to have a look at is misconduct. So, what are the grounds for dismissal in relation to misconduct? Well, misconduct can involve a range of different behaviours. Typically, many forms of the main forms of misconduct are listed in employment agreements. Although these are seldom exhaustive. Exhaustive means that includes everything that's on the list, and it doesn't include anything that isn't on the list. So they're lists of examples of sorts of misconduct, but they leave themselves open for other forms of unspecified behaviour. Misconduct, where it's established, can result in disciplinary action. That disciplinary action can take the form of formal warnings, or in serious cases of serious dismissal, it can take the serious misconduct. It can result in instant dismissal, which can be justified. So what constitutes misconduct, and how serious does it have to be to merit a formal warning or instant dismissal? These questions correspond actually to a two-stage test at law. The first is, was the conduct capable of amounting to serious misconduct? So this is looking at the nature of the conduct itself. And secondly, was the dismissal or the other sanction warranted in the circumstances? And you do need to look at both of those things, because simply establishing that there was misconduct or there was serious misconduct does not automatically lead to a particular form of disciplinary outcome. Whether something constitutes serious misconduct goes beyond what is written in employment agreements. So you can't just say that something is serious misconduct because it's listed in an employment agreement that that's serious misconduct, and you breached it, and therefore you can be instantly dismissed. Clauses. There are clauses in employment agreements that list behaviours that are deemed to be serious misconduct. That doesn't necessarily mean that they are. And they also sometimes include comments about zero tolerance to various things. And again, just that it's the fact that it's written in the employment agreement and defined as serious misconduct, or claimed to be serious misconduct, or said that there'll be no tolerance on these sorts of behaviours, does not automatically mean that it actually is serious misconduct. That's a judgment that needs to be made, or that can be made by considering all the circumstances. But the essence of what constitutes serious misconduct is actually set out, and that is that it is conduct that seriously undermines the implied term of trust and confidence that the employer can expect to have in the employee. So that's what's required. It doesn't need to be endangering the public. It doesn't need to be various other things, but it's the employment relationship is supposed to be one where each party can have trust and confidence in the other. And what is defined in order to count something as serious misconduct, it has to seriously undermine the ability of the employer to have trust and confidence in the employee. And so that might mean that that a single act might constitute serious misconduct in some contexts, but not in others. It all depends on the facts and circumstances of the case. Smoking, for example, might be a minor transgression in some circumstances, or it could, and it often is, grounds for instant dismissal, like in a building operated by the employer where smoking is prohibited by law, like in a hotel or something, or a school, or a health and safety risk, such as with hazardous substances, or in areas of food preparation. So It isn't the act itself; it's the circumstances surrounding it that are assessed when it's to determine whether something constitutes serious misconduct or not. There's also some conduct that can be carried out before an employment relationship begins that can constitute grounds for dismissal, such as misrepresentation or non-disclosure. Now, it doesn't automatically follow, but depending on what the circumstances are. So there are examples. For example, in this case, Secretary of Justice against the New Zealand PSA, a prison guard was dismissed on the grounds that he failed to disclose criminal convictions. Now, that doesn't necessarily mean that anybody who fails to disclose criminal convictions can be dismissed for that, but the court ruled in this case that given the occupation, that he was a prison guard, and given the nature of the information that was not disclosed, that he had criminal convictions, that combination of things met the threshold for saying that this was grounds for this single act to be justifiable grounds for dismissal. Now, it's also the case that I said, this two-step rule that you need to establish the nature of the conduct and then whether justification was justifiable. There are cases where serious misconduct has been established, but where dismissal is found to be unjustifiable. And this is an interesting case of the Secretary for Justice and Dodd with a court worker. This is an interesting case in that it was accepted, never contested, that there had been serious misconduct on the part of the employee. And that serious misconduct normally would constitute grounds for instant dismissal. But in these circumstances, the court ruled that it did not, on its own, constitute justifiable grounds for dismissal, and said that, among other things, said that the employer should have considered other forms of sanction short of dismissal. That's an interesting case to have a look at, and there's an interesting commentary on the case if you don't want to read the whole thing in that link there. So what is the test for justification? The Dodd case that I've just mentioned is an unusual case in that it's an example of serious misconduct not justifying dismissal, because normally establish serious misconduct and you can then justify dismissal. So it's unusual when you can't. But there are two other aspects of the Dodd case that are not unusual and are worth noting. The first is that, as is mentioned in that commentary, and I'd encourage you to read that commentary, the judgment was made before changes were made to Section 103A of the Employment Relations Act that sets out the test for justification of a dismissal. So this was a change introduced by National, and this was the clause here, by consider that the test of justification was determined by considering whether the employer's actions and how the employer acted were what a fair and reasonable employer would have done. That's what it had previously said, what a fair and reasonable employer would have done. And the change that was made is that would was changed to could. So the test for justification now is assessing, considering whether the employer's actions and how the employer acted were what a fair and reasonable employer could have done. And that is a significant difference. The new test is based on the view that there is more than one possible course of action that a reasonable employer might take. Previously, the court was required to say, put themselves in the position of a reasonable employer and say, I'm a reasonable employer, what would I do? There being only one course. What this has done is it's basically broadened it out and included a wider range of actions that an employer could take that could be deemed as justifiable. So it's made the the task of people establishing that this was unjustifiable more difficult, and included more things within the bounds of what would be justifiable. The other thing about the Dodd case is that it highlights problems with processes by which suspected misconduct was identified and investigated and a course of action decided upon. Again, read that commentary. It's quite interesting when it set out those things. So it's possible that even without the conclusion, the process was pretty seriously flawed. And when we look at this, the expectations of how a disciplinary investigation is conducted, we find principles very similar to those, and certainly compatible with those of principles of natural justice that we've already discussed that are being applied. At common law, that is the law that's been developed through cases set by judges and courts and so on, the test for fair procedure was best set out, in this case here, this Unilever case, back in 1990. In that case, Judge Goddard established sort of a broad approach, which is still retained today, of looking at procedural flaws by assessing the overall substance and the overall fairness of the procedure, rather than kind of nitpicking for technical flaws in procedure in a process that Judge Goddard referred to as pedantic scrutiny. He was saying, we are not going to go through this whole process with a fine-tooth comb, trying to find little errors in it. We are trying to make an assessment of the overall impact of whether this and process of, was this a fair process of investigation, and so on. That common law approach has also since been supplemented by statute, and the statutory provisions about what constitutes a fair process are set out in section 103A of the Employment Relations Act. So let's just have a look at that now. So the first part there basically just says, look at section 2, saying that, this is what the test is. And the test says there, the test is whether the employer's actions and how the employer acted were what a fair and reasonable employer could have done in all the circumstances at the time the dismissal or action occurred. So this is that what a fair and reasonable employer could have done. And then goes on further to say, in applying this test in subsection 2, the authority, the Employment Relations Authority or the Employment Court, must consider the following. And here they set out some of these things. Whether, having regard to the resources available to the employer sufficiently investigated the allegations against the employee before dismissing or taking action. So was there a sufficient investigation? Whether the employer raised the concerns that the employer had with the employee before dismissing or taking action against the employee. Whether the employer gave the employee a reasonable opportunity to respond to the employer's concerns before dismissing or taking action against the employee. Whether the employer genuinely considered the employee's explanation, if any, in relation to the allegations against the employee before dismissing or taking the action against it. So this is, see, very similar sorts of principles to the principles of natural justice, but they are actually set out in statute. So, and the court must look at those. It doesn't say that the court, this is all the court looks at, but it must look at those things. And that fourth one there, 3D, is really looking at also issues of predetermination. And that's one thing where processes can often be challenged if there is evidence that there isn't a genuine openness of explanation, but there is a predetermined view that the employer has, and if there's any whiff of that, and not really being open-minded as to alternative explanations, then that is a serious flaw with the process. And as I said, number 4 there, in addition to those factors, so they have to look at those factors, but the authority or court may consider any other factors it thinks appropriate. So this is an example of a non-exhaustive list. This is a list of things you have to do, but you can do other things as well. And then finally, which sort of sums up that overall approach of the case that Judge Goddard set out that I just discussed before, the authority or court must not determine a dismissal or an action to be unjustifiable under the section solely because of defects in the process followed by the employer if the defects were minor and did not result in the employee being treated unfairly. So the defects in process need to be worse than minor, and they need to have had the effect of treating the employee unfairly. So you're not going to get it thrown out on a technicality. So just to conclude on this, in any procedure relating to disciplinary action by an employer, the onus is on the employer to be able to demonstrate that in the circumstances the sanction that was taken against the employee right up to and including dismissal was justified. There are reasonably clear guidelines in statute and in case law to guide what is justifiable procedure and decision at the end of that. So you're not flying blind in this sort of thing. There is a lot to be able to shape how you deal with this. And if you want to have a good, reasonably up-to-date discussion of analysis of that, there's a link there to a paper discussing this issue of disciplinary proceedings and misconduct that I think you'll probably find pretty helpful.